this case, my lord, I seek a lot of point permission. File one application, Lord, because the reason is, Lord, that Lord, they have referred to Bhagwan Krishna to prove that consequential amendments and other subsequent steps taken in pursuance thereof shall also stand invalid. That is what, Lord, the petitioner has said. Now, Lord, what I have done, Lord, up to the Supreme Court, Lord, I have taken copy of the entire Bhagwan Krishna's petition. And Lord, I have found out that what is the meaning of consequential amendment and other subsequent steps taken in pursuance thereof. And it does not include appointment, my Lord. I'm sorry, because this may not be relevant for today. The supplication is taken on record. Then, Lord, I will argue the matter.
Mr. Kalra, you are Mr. Kalra.
Very well, my lord.
Please wait for your turn.
From the last occasion, please move to the last order.
And that is what we are reading.
Yes, Lord. The Lordship said that we will await the judgment of the Honorable Supreme Court in an IA filed by the B.Ed degree holders to say that those appointed should not be removed. On this basis, my lord, they have been seeking adjournment time and again, and therefore, your Lordship observed that if the application is not decided, it will be heard finally. My lord, fortunately, the application was dismissed by the Honorable Supreme Court by the very same bench which decided Devesh Sharma. The applications of the B.Ed degree holder are again and continued.
Where is the order? You want to file what, son?
Lord, I want to file on IA, whose permission, Lord, I am seeking from my Lord.
IA for what?
Lord, this IA is for disposal of the case. Total purpose is, Lord, that is Krishna which was
You are appearing. You are appearing.
Hello, sir. May I would to appear?
People, Lord, who are B.Ed, who are working as primary school teachers. And my Lord, what my contention is.
Your clients are B.Ed degree holder and then they have been appointed.
In March and all, we are appointed, we are serving. Now, our contention is, Lord, that the Supreme Court in Devesh Sharma's case, Lord, has saved those appointments, my Lord, which were done prior to 11/8/2023, and I am filing documents to that. Say,
Hello, this is completely an incorrect statement. We have been appearing in Devesh Sharma, including in the matters taken up by the Supreme Court thereafter. And I must point out, the Honorable Supreme Court upheld the judgment passed by Rajasthan High Court.
Arora, we come to you. We come to you. Let me have a voice.
the other day, only one thing, Lord. Why I want to file this? The other friend on the other day was
Where is your application?
It will not be filed as of now.
What is the prayer you are making for dismissal? All right.
One of the petitions, there are two petitions. One of the petitions is already rendered instructional.
Yes.
That is not casing in this case.
Yes.
On the last date also, we have produced the orders for appointment. These two petitioners have already been appointed as primary teachers. Their applications have been rendered instructional. Therefore, Lord, that first petition, that petition may kindly be dismissed as instruction because they have already been given appointment.
Yes.
Now they are misleading the court by saying
Just one by one.
Yes, even on the last date,
Now, Mr. Villa, please clarify.
Yes.
You want dismissal of a particular petition because they are appointed. Who are appointed?
Kesri Kangal and Chaudhary.
They were diploma holders or they were.
They were the D.El.Ed candidates who
D.El.Ed.
filed the petition before this court.
Who is for the petitioner?
They are the five submitting.
Yes.
Before the appointments were made, the writ petitions of five challenging the notification of the NCT and the rules of the state to state that B.Ed degree holders cannot be made eligible for level 1. Your Lordship passed the order that all the appointments shall be subject to the outcome of the Devesh Sharma judgment, wherein the Rajasthan High Court judgment to say that the B.Ed degree holders are not eligible is under challenge. Now, during the pendence of the writ petitions, appointments were made. Out of the bunch of the petition, in one of the petition, two petitioners have been given appointment. Rest of the petitioners
here. Correct.
All right.
So last question, what we have said.
Just to note that it is subject to final outcome. So unless final.
Devesh Sharma is finally decided. And again, health ticket holders are not eligible. No longer say that consequences have to follow once the notification has been filed.
Please read the complete credit provision that someone will see in which
This is clear. Just a minute. Your cause has become infectious or not?
No.
Yes.
But why not?
What the regarded my petitioners are not in your appointment. Only petitioners have been rest of the petitioners who I am presenting, they have not been for
Only petitioners are there.
Only two.
there are two petitions. Yes, sir. Now petition में दो petitioner हैं.
Has somebody produced appointment or not?
Last slide में produce किया सर.
Vipin Kumar, no one has been given appointment.
We are not talking about Vipin first. Case number.
Now, honestly,
We are talking
now
about
it's done. Now my title was listed. They said that we have looked at application for under board stated all those appointments made prior to the notification should be safeguarded. The Honorable Supreme Court is seized with the matter. The lordship of the order that we wait for that outcome. In case it is not being clarified, then we will proceed on merits. Fortunately, the application of B.Ed degree holders would remain in office. Only pretext that the appointments were prior to the order of the Honorable Supreme Court had been discussed after hearing all the concerned parties. That order of 11/2023, 2024, we have placed it before your lordship with the compilation. Now, our entire things are very much clear. The Rajasthan High Court quite.
So all right, we'll hear it.
Oh, we can put it on the ground and we are moving this application for data.
These are the forward PC. These are the two orders of appointment whereby the person is Kesri Nandan. Both the petitioners, he is talking about Vipin Kumar. He is appelling Vipin Kumar. He has no say in the Kesri Nandan. Kesri Nandan's case, both these appointments or these are the appointment orders, both the petitioners have been appointed. So let that first that petition be decided and then we address on
There are only two.
Lords, I have something to say there. I don't think whether it can be really correct in that submission that he's making. Now, before my lords, there are three petitions as far as I can see.
Please one by one. I can't share two learned counsel at the same time. Please.
Now, I will look on these orders. These are the two orders whereby these two petitioners have been appointed. So let that first Kesri Nandan's case be decided.
Why not? We are having a very voluminous report.
Which is Kesri Nandan.
That is definitely correct.
Kesri Nandan go on to me or
One thing Nandan, they want
13768.
my learned friend can't oppose the dismissal of you.
He has no say in the Kesri Nandan. He has no say in the
It's an order that all appointments shall be subject to the outcome of the Devesh Sharma was in the case.
He does not get the license.
Supreme Nandan Bharat all other petitions for tagging.
He does
What
not
we
get
want is if the case is declared infructuous, the interim order of the appointment is subject to Devesh Sharma would also be.
Kesri Nandan is not rendered infructuous. He has no say in the matter.
Yes.
What was your prayer? Let us see. Kesri Nandan.
Yes. My lords may have a look at the prayers in Kesri Nandan. I appear there.
The council of Devesh Nandan will be what how it will make any difference.
No renders on Kesri Nandan. This is what I'm saying.
Also, can you see page 49 of Kesri Nandan? Honorable Court may kindly please to impugn notification dated 28/6/2018 and 30th May 2018 issued by NCT making amendments under notification dated 23rd August 2018 issued by MHRD Department of School Education Government of India. Whereby candidates pursuing qualification of B.Ed have been made eligible for the post of primary level teachers may kindly to declare illegal and arbitrarily ultra virus of the Constitution of India. And mandate of RT Act 2009 to appoint quality teachers and therefore it may kindly be working set aside. Thank you, Honorable.
The next prayer also, please. Yes, if you may leave.
Second, I think Honorable Court may kindly please to appropriate the order or direction not to treat B.Ed candidates as eligible for the post of primary level teachers in schools under RT 2009.
These issues have been adjudicated now.
He is
Finally, by the Supreme Court.
So, yes.
And you also seek appointment.
We also seek appointment.
That has been given.
Yes.
No, now there is a difference. The first petition was placed in the lost to pass the order that appointments have not taken place, but they shall be given appointment, all the persons selected, subject to outcome of the commission. Then came other petitions also which were tied to the lead file of this case in London. Now, out of these bunch of the petitions, in case in London, there were two petitioners who have now been given appointment. Now, whether these persons who have got appointment will make all of the petitions infructuous for the reason, Manav, what they want to say is that if it is declared infructuous, the interim order of making all appointments applies to will also go. Now, as in that case, we who are otherwise meritorious and have not been given appointment, Manav, we will be ousted. These persons.
So we are only talking about one petition.
Yes, we are talking about.
I appear in Kesari Nandan. May I have something to say there? And I think a lot has been said there without even hearing us out. My lords, first of all, my learned colleague there read the prayers.
However, what was waiting for clarification in respect to other
Like, instead of going into all that, let us hear it from you.
fine, not that.
That is listening for.
My lords, may I make a submission, please, if my lords may allow?
Your Lordship can also ascertain, Lord, whether these two petitioners have accepted their appointment subject to their petition. They have unconditionally accepted it. Not so at least this petition cannot stand.
My lords,
Even as
I am the
this is the only one which
I
is
am
filed
appearing for the petitioner. May I make some submissions?
So let us hear the council who are appearing one by one.
Yes, so my lords, I appear for the petitioner. Let me make that first submission.
Which case are you appearing?
My lords, I am in Kesari Nandan, Saho. So now, my learned colleague present there before my lords read the prayers in Kesari Nandan. The prayers as have been made are in REM. They are on a larger principle on that particular notification, not to treat the B.Ed candidates and to grant liberty to the state to only treat BSTC candidates. Then they ask for an interim relief that any appointments to be so made will be subject to the outcome of what is decided there. Now, my lords have also granted that particular relief here. So, the appointment, if any, made as on date is subject to the outcome what my lords will decide. It is very convenient to say, dismiss the petition without that particular confirmation, because tomorrow if my lords were to take a view which is different, I who have been appointed will be out. Now, I support this particular contention, and therefore my lords will need to authoritatively pronounce today. It is my respectful submission that on the last day, now every day there is a changing stand and a different positions that are being taken. On the last day before my lords will recollect, please take that order of 4th of January 2024. The objection that was sought to be taken to defer the hearings of this matter is that one application is pending before the Honorable Supreme Court in the Divesh Sharma matter to say that such persons having B.Ed degrees or whose processes had commenced at that point in time should be given the benefit of the appointments and they should not be disturbed. That was Arnab Ghosh application which was specifically cited before my lords. My lords may take a look at the order passed on 4th of January. I have a copy before me, and if I may just point that out, if I can read the first paragraph of that order. After hearing counsels for rival parties and facts which have been brought to the notice of this court, an application for clarification bearing number MA2206 of 2023 is still pending consideration before Apex Court and is tentatively listed before a bench on 11 January 2024. As per the website, it would be appropriate to await the verdict of the Apex Court. Now, my lords, this application was relied upon because this application virtually said that all those who have been already, the process who has been commenced in respect of those B.Ed candidates, they may not be ousted. My lords, the registrar had dismissed, the application came up before the Supreme Court. The Honorable Supreme Court has since dismissed that application by its order. We have placed a convenience compilation before my lords where this order has been annexed. And if my colleague out there can just pass this convenience compilation to my lords.
No, just one clarification here.
One
Sorry to
minute,
interject.
I am
Just sorry to interject, Lord, but we have to clarify that this is not a case, Lord, where they have been appointed. In Arnab, nobody has been appointed. That clarification needs to be stated before the court. Can't be not misleading.
Lord, that
My
much.
lords, may I just complete this?
Yeah,
Who is Kesri Nandan to say all this?
Yes, Mr. Luka, let
Even
him
you say
complete.
that she's representing some other
Let
client.
him complete. I cannot hear two persons at the same time. Let him complete one by one. Please complete your arguments, whatever you want to say.
Would my lords have seen the previous order passed on 4th January
You
and
are
now
appearing for Kesri Nandan. You are appearing in
I am appearing in the matter for Kesri Nandan, my lords. I am appearing in that matter.
So why has it not become infructuous, you are saying, because this...
For the simple reason that my appointment is subject to the final outcome, still, my lords will take the larger decision. All the three matters are connected. It is the
No,
same
final,
issue.
just a minute, final outcome in what?
My lord's final outcome in the present petitions, and all the three petitions are connected. They all raise the same issue.
Fine.
They are on identical reliefs.
So,
And my lords have tagged all these matters together. So to say merely because Kesri Nandan has been today selected or has been given a letter of appointment, and that appointment is subject to my lord's order or subject to the outcome. Now, if my lords were to take a different view in the connected matters, and it is said that my petition has become infructuous, and my lords take a different view in the connected matters, I would stand to suffer a different position.
okay.
And in any case,
Just-
my prayers are
just a
there.
minute,
My
just a minute.
prayers.
Please, just a minute. Can we take a different view than the view of the apex court?
No, my lords, from the apex court, and
We can't.
that's exactly what I am requesting my lords to do.
So,
I am requesting my lords.
the only question before this court is whether to oust the B.Ed candidates, appointees or not. That is all.
Yes.
We cannot take a different view so far as the issue decided by the Supreme Court is concerned. Please,
I am grateful, my lords. So, my lords, so far as that aspect is concerned, I would like to bring to your notice that a large number of applications have been filed from time to time before the Honorable Supreme Court. I would request somebody to pass over that application, the compilation of orders which are from the Supreme Court from time to time in diverse applications, including in fresh writ petitions where similar prayers have been made. And my lords, in each one of them, either after hearing the matters for some time, they have been withdrawn, or the same have been dismissed with costs in certain cases. Now, that convenience compilation, if my
But my lord,
anyone out there
we had tendered, my lord, contract compilation, it's a short compilation, it says time taken by the Honorable Supreme Court. There is a hard copy that my colleague has tendered in court.
No, I was we have the firm view that we cannot take a different decision.
Very well.
That has been written in the
We-
My lord,
Supreme Court.
the compilation can be seen for
Only question left is whether the B.Ed appointees are to be ousted or not ousted. That is all.
Because this has also been decided by the Honorable Supreme Court. That is what we
No,
don't
no,
this has been decided, my
So
lords.
sorry.
Please arrange your matters. We are
So, my
hearing.
lords, therefore, if my lords may take the convenience compilation, I will show those orders, please. Allow me.
My humble request only is not
Lord.
opinion will not.
My lords, the first order in that convenience compilation is Supreme Court in Bhagwan Krishna.
On regard, because it places important documents not on, that's my total submission. Because Lord, my learned friend has been harping upon the observation regarding consequential advertisements. I have demolished that Lord in this application for dismissal. Lord, please see this application, which copy of which I have given to my Lord just now. Let it read the record and let
You are for?
I for the proposed intervener, Lord, responded, they only proposed responding.
Who are those? Who are your clients?
My client is not unsure.
No, and we are about
We
B.Ed appointees.
Lord, I'm also here for
On the
something
question
else.
whether you should be in or out. That's all.
Lordship may hear us, Lord.
So, may I, my lords, show those order sheets if my lords will permit me that?
Just a minute.
Yes.
Some date which because there has to be a compilation of what has happened, what has transpired in various states of the country.
Yes.
In some of the states, the appointments have been saved.
Yes, Lord.
That's a completely incorrect
Just,
statement.
Yes, sir.
No, that is for the state government to come out.
Lord, in Calcutta, Bihar,
Whether you are wanting to save them, and if you want to save them, then under what provision? Please tell us.
yes, Lord,
Let's make a submission. The notification that allowed the B.Ed candidates to join, issued by NCTE, is under the central legislation. It's a central act. Now, the notification applies even if it is issued pan-India across the country, which makes B.Ed as an eligible. Now, that notification has been struck down by Rajasthan High Court, upheld by the Supreme Court. Once the notification that makes a qualification of B.Ed is not eligible for the purpose of appointment to primary teachers, we should under a central statute applicable across the country. My lords, it's not then open to anyone.
What is the stand of the state?
They should be submitted a reply in most of the cases.
No, what is your stand?
Stand is for option.
Whether the B.Ed appointees are out or in? Whether they. No, after the Supreme Court judgment, what do you maintain?
maybe.
After the appointment, and the appointment was much prior to the order passed.
Yes.
Right.
Because prior to the order passed by the
Right.
Honorable Apex.
Now, do you want to save the appointments? And if you want to save them, then under what provision?
All these documents
And will that be at the cost of depriving somebody else who is more eligible or in fact eligible? Then how would you accommodate? How would you?
May I just clarify that as well?
Just
rules and then framed by the state government independently, those have never been declared otherwise. They were not subject matter of challenge before the office.
Yes.
State rules will be subject
Yes,
to
Lord. Lord, that is a very important distinction. Lord, may I submit, Lord, that is a very important
I'm sorry, Manoj, there is.
distinction between B.Ed Sharma and the present case. That will have to be brought out, Lord.
under Devesh Sharma's case, Devesh Sharma's case is a recital.
Nobody was appointed in that case.
But
In this
so
case,
to this
everybody-
court, I think it's better that you all don't want to argue the matter finally.
That's what we see.
Our stand should be the record we have prepared.
Devesh Sharma's case is a recital of.
No, please decide whether you want to argue or not. Has the state filed any reply?
They have filed special petition also. Which they are required to file.
There is a return. What return is of
Isli Nangal and some connected matter.
return of the interveners.
सर अगर आप 2 मिनट हमको सुन लें, हम ये बताना सर 2 मिनट अगर आप हमको सुन लें, सुप्रीम कोर्ट के जजमेंट की बार बार बात हो रही है देवेश शर्मा की केस। सर देवेश शर्मा का रिपरकशंस क्या है पहले? देवेश शर्मा is the recital of law. It only says that the candidates who were any B.Ed or they were ineligible and the persons having diploma were the eligible candidate. The matter was before the Supreme Court. The appointments made before during that period was before the Supreme. There are a number of applications which have been filed to dislodge these persons who have B.Ed and who are appointed. There are a number of applications. In none of the cases let them produce even a single order where the Supreme Court has said that the appointments have already been made should be annulled. Now, every time they make an appointment,
That is why the matter was listed.
so therefore, what I'm trying to submit is that it's not like this that the Supreme Court has something said in Devesh Sharma, therefore all appointments will go. ये भगवान स्टेटमेंट देते हैं भगवान किसका भगवान के स्टेटमेंट भगवान की
Please tell us whether you would like to argue the matter today or not. I say,
May I make one thing for consideration of this court? There is a submission that I make and I think it has some relevance. My lords will appreciate one thing, that the notification of NCTE was struck down on 25th November 2021 by the Rajasthan High Court. 25th November 2021, no appointments of B.Ed could have been made at
She is.
because it gained.
Here because she is an advocate, my lord. Please see.
No personal comments, please. Yes.
No,
We take it on record, there's no problem. But please tell us whether you are ready to argue or not.
Fellows, I am ready to go on if you would allow me. I'm for the petitioner and I think I have a right to be heard, my lords.
Cases,
We all have.
cases pending since more than 1 year.
In fact, Your Lordship,
You have not filed a reply in the last 1 year.
the reply is filed.
Where is the reply? I can't find the reply here. State government's reply.
It is there in our matter also. Vipin Kumar Dwivedi, they have filed a reply.
There's some reply of the intervener.
No, there is a reply by state also, my lord.
The connected case.
Yes, Lord. Vipin Kumar Dwivedi, I can see a
Which
copy
case?
by the state.
Sri Nandan में कहाँ है जवाब?
Kesri Nandan. Sorry, Kesri Nandan also. They filed it on 4th of December, my lord.
Return. There are two return.
Returned by
One is
respondents 3 to 5.
intervener. The other is
In fact, in one of them is filed subsequently. After filing our return.
this is respondent number 3 to 5. Who are 3 to
Yes.
5? 3 to 5 is 68. Your return is there, Amrit. Yes, yes.
In 26.4 is not final.
They are all same. Yes. We are one different. And what is your stand? What is your stand in this return?
That stand, Your Lordship, that the appointments were made
Hmm.
prior to the judgment passed by the in pursuance to the rules made by the
What is struck down?
so
My lords, may I show the stand if my lords would like
Allow
to
them
see
to place their reply.
paragraph 19 of the state's affidavit. My lords, that is why I mentioned that the Rajasthan High Court judgment is of 25th November 2021. And if my
We are
lords
talking
may
about
turn to paragraph 19 in Kesri Nandan, the reply of the state, the stand is clear. Please
My
see
friends are
paragraph
talking about
19
the
and
High Court
20.
judgment, my lord. Your lordships are asking about the Supreme Court judgment. My lord, my friend is talking about the High Court judgment.
My lords, I don't understand this. The High Court quashed a notification. The Supreme Court only said no stay of the judgment, only subject to the outcome. The day the notification is quashed for the country because it's a central legislation. This is not a state.
No, what have you
Miss
said
Mona,
about
can you
the
please
consequence
argue
of the
your turn?
Supreme Court judgment? Where have you said in your return?
Correct.
So what will happen after the Supreme Court judgment? What have you
My
what
lords,
is the stand on
the
that?
Supreme Court judgment upholds the quashing of that notification. Apropos to quashing of a notification which made B.Ed a qualification eligible for primary teachers, that B.Ed
It's
qualification
not
is
from your return. Where have you said this?
Kindly say don't discuss
Some
paragraph 21.
I am on the fact of the appointments having made because today Supreme Court qualification is that they are no longer eligible.
My lord.
Paragraph 21 of the reply, my lord. Paragraph 21. And also there is also the Supreme Court.
Yes, Lord. Recently on 11th of January 2024, that application was rejected. In that application an averment was made that the appointments made Lord prior to 11/8 2022 should also be quashed. So we want intervention, we want to put this point. The Supreme Court rejected that.
No, because approach was
11th one.
No.
approach was
11th one. I submit that was misrepresenting the effect of that.
Please argue the matter. All these points will be thrashed out if you have to decide the matter.
May I, on behalf of the petitioner in at least in Kesri Nandan, start my arguments, my lords, without my learned friends on the other side just ignoring.
Are you all with us in the final hearing aspect or not?
I want to start the final argument on this matter.
All right, we'll fix it tomorrow then.
They will never
Asking to at least tell us their stand.
But this paragraph number 23, that is actually from this slide. See, that considering the portrait since the rules issued by the state of MP prescribing requisite funds, the primary teacher was never subject matter of challenge before the Honorable Court of Rajasthan or Honorable Appellate Court. Selection and recruitment process has been on basis, and substantial number of candidates have already been duly appointed and working on their respective posts as primary teachers. In view of the portrait, unsettling the already settled position may not be in the interest of justice.
Yes.
For this, there's so many
Stand on record.
Yes.
Stand there on record.
It's on record.
We want to save the appointments.
It's on record.
So can we argue one by one, 10 minutes each, we can get and we'll put our point. Just give us 10 minutes to do.
All.
In the petitioner, just 10 minutes.
Today we have listed two matters as passed over which have to be finally heard. We take it up tomorrow.
And may I make a prayer, not if in case your lordships are not taking it up today, can it be next week?
No, because we are opposing that. We are opposing
Because
that.
let it be tomorrow. Let it be tomorrow. Let it be tomorrow, my lord.
And
Because
we saying
it's been
that
pending too long.
3 days accommodation, my lord. Next week, anytime, my lord.
Opposing that, because we are opposing that. We are vehemently opposing that.
Today we are ready.
In fact, this issue, Manoj, whether B.Ed have to be out has also been decided by the Supreme Court in subsequent matters.
We also have our submissions to
Tomorrow also we have a bunch of to be heard finally. So you can take your chance.
What we are requesting,
Very well, lord. Very well, we take a chance, lord, tomorrow.
no amendment will be done. On that.
That is what we had said last time.
No one is seeking for an adjournment. Today.
Incorrect statement.
My lord,
I'm not clear, please see the order. I just want to point it out for every time when there is misleading statement. Can you see one of the order dated
So we'll hear you tomorrow, Mr.
Yes, lord.
See, if it is possible, to hear it, otherwise we'll give you some other.
Very well, but we take a chance tomorrow, lord. Oblige.
my lord, I only wish that as a petitioner, if I can be heard without being interrupted by the other side on the VC for barely 15-20 minutes, I'll be able to conclude my argument.
So tomorrow at 3:30, will it be fine?
Very best.
I do that.
1 hour, you start with 1 hour, at least argue for 1 hour and then we'll,
Yes, my lord.
no, 15, no, we have some matters. Yesterday, tomorrow we have. We give you 1 hour's time to start your arguments and to carry out whatever submissions you have to make, and then if it's not possible at 4:30, then you may we'll spill it over. It will spill over to the next day.
Because can I just take 30 seconds by walk? No, can I just take 30 seconds? Just 30 seconds.
But anyway, the matter is.
Can I just take 30 seconds? Because the prayer whether B.Ed prior to Supreme Court judgment are to be considered or not has been decided by the Supreme Court subsequently. And all of those applications have been
I'm
dismissed with costs. So
I'm sorry,
just once again,
Can we
if
argue
you don't
about
mind,
these stuff?
if you don't
I'm so
mind,
sorry.
if you
This
don't
is
mind,
incorrect.
if you don't mind, please.
Completely incorrect.
If you don't mind,
Please don't make that.
So all of those applications with prayer I have produced before my lord. The prayer is to regularize. And all of them have been dismissed with cost. The last one being day before yesterday. I have produced the prayer also before my lords.
Consulting.
Well, if the other side agrees.
We have obsessions, they never want this person to be
Because
obsessed.
the prayer petition not
Sorry?
their petition, not your petition. We have to hear their petition. If please take a consent from them.
1.5 years, they did file the reply. Or when the lordship was to speak to them, then they came up with the reply.
In fact, it is in their favor to seek an adjournment.
All of those different.
Who is asking?
So, alright, we will paucity of time, let this case be taken up for the hearing tomorrow in motion at 3:30.
All right. Oblige me.
We'll see, sometimes these bunches get adjourned. We'll see. Time permits.
Well, could we give a short note as to who would argue so that it will be easier, so that everyone doesn't speak at the same time tomorrow? Can we just